Starbucks is taking center stage at the Supreme Court. Now, 2 years ago, Starbucks fired 7 baristas who were organizing a union at a Tennessee store. The company says they had a right to fire these employees because the workers violated company policy by inviting a TV news crew into the store after working hours. But the employees claim Starbucks fired them because of their union activity, which the National Labor Relations Board agreed with. A judge approved the board's request to reinstate the workers. The case now finds itself before the Supreme Court because Starbucks is challenging the standard that federal judges have used to determine whether workers should get their jobs back after unionizing.
SCOTUS will look at the power of the National Labor Relations Board around workers' reinstatement to a place of business. Now, many fear that a ruling against the NLRB could weaken labor organizing in other situations.
So this is a case that has incredible consequences for all unionizing or aspiring unionizing workers across the country. So one of the problems, one of the significant obstacles that workers trying to unionize their workplace face is obviously retaliation. And if it is the case that you can contest that retaliation, but the legal process is so stretched out and prolonged that you are going without a job for years, going without health benefits, your family potentially losing health benefits in the midst of an illness, and all of the horrible things that we know can happen when people become unemployed, then whether or not you're eventually vindicated down the road doesn't mean that much to you. What you're going to do is try to avoid at all costs being fired and therefore avoid unionizing in the first place, which is the goal of companies like Starbucks. And Starbucks, mind you, has seen hundreds of locations over the past few years unionize in a really unprecedented way, and they are very eager to stop that trend from happening. So what's at stake here is whether or not the NLRB can kind of abbreviate the process and say, you were retaliated against, you can get your job back in the interim, in a way that really helps to shore up people's willingness and protect employees as they're going through this unionizing process. Now, what Starbucks is saying is that the standard that the NLRB uses to evaluate whether or not someone should be reinstated to their job is too low, and that they should be using a higher standard. And if it is the case that the Supreme Court agrees, that basically means that if you are trying to unionize in other places, other contexts all around America, it is going to be much more difficult for you to simply get your job back when you are retaliated against.
Yeah, it's called a 10J injunction. It's what the NLRB uses to go to a court and then force the company to hold off on doing an enforcement action while this issue is pending. It's basically the only thing the NLRB can do, so this is a pretty pivotal case. Obviously, in reading the commentary about it at the Washington Post and NPR, it seems to me that legal experts who are friendly to the NLRB and want this power retained are saying that they're worried that this case, because of the fact that the TV camera crew incident does give Starbucks a reason to do the firing action, that they're going to rule with Starbucks in this case in a way that will be damaging to a lot of other labor actions, because there is like a pretext for it in this case for the NLRB.
Yeah, I mean, the problem with these cases, I mean, we've had this debate before about whether or not people who are discriminated against based on some aspect of their identity should simply bring an EEOC claim, and whether or not these mechanisms are really efficient. The problem is that employers are very, very good at coming up with some pretext for letting you go. Have you ever been sick? Have you ever been late?
I'm sick
have
right
you
now.
Have you ever violated company policy? Well, most of us have not been perfect employees. So the problem is employers are very able, very ready to use any pretext in the world to justify firing someone, even if it's for prohibited reasons like union activity, or because of their race, or because of their sexual identity, or any of those kinds of things. So frankly, the onus, the reason that we have a National Labor Relations Board, the reason that we have some of these standards is understanding that if you take these businesses at face value, they're never going to be able to be held accountable for illegal retaliatory behavior. So again, I mean, you're right in what you describe as the stakes of this, but precisely because the invitation of a news crew might seem like it's not something that I would have done. When you look through the kinds of pretexts that are used by companies to justify firing employees, you find the kinds of things that might be very familiar in your own behavior, and you'll realize that there, but for the grace of God go I. And basically, retaliation will be sanctioned constructively if there aren't these kind of mechanisms to back workers up. One other aspect of the story that has gotten a little bit of a play is that the attorney who will be arguing the case for Starbucks is a woman named Lisa Blatt. And in a classic kind of neoliberal identity politics sort of a way, some are celebrating her because it will be her 50th case before the Supreme Court, which is a notable it's a first for a woman arguing cases before the Supreme Court. And people who are invested in the interests of labor, the leftists and the like, are apoplectic over the idea that any kind of publications or legal licensing board, legal organizations would celebrate somebody for that kind of achievement on the basis of her identity, when the consequences of her litigating this case successfully would be to ruin the employment opportunities for millions of women across the country who, what I would argue's interests supersede that of one elite attorney.
What news publication is doing this, or is this just out there in the ecosystem?
I see it in a lot of the kind of legal news media coverage. I see a couple of screen grabs. I'm sorry. Otherwise, I would click through and tell you just who wrote this, but it's been cut off in some of the tweets that I'm looking at. But this was a similar issue with, remember when Neil Cattell, I forget.
Neil
Cattell was litigating the Nestle case, and there was some celebration of what it meant for him to be litigating this case. But it was a child labor case that he was defending Nestle against. So these things always have their contours, and it's always frustrating to see what certain identity politics centered coverage will focus on. But it really is the case that this has far-reaching implications. We don't see a lot of coverage of this story. I'm so glad we're doing it today, precisely because so many newspapers have fired their labor journalists. They don't have a labor beat anymore.
Because they tried to unionize the place. We disagree ideologically on this. I think that I don't want to make it harder for employers to fire people if they think they should get rid of that employee. I don't want to involve the government in that, and you don't have to work for them if you don't like the kind of work environment you have going on there, would be my response. But we don't agree, and probably most of the audience agrees with you on this one. So.
Oh yes, I'm reminded about our child labor law debates of late.
Yeah, I think kids working is fine and character building for them, and is not something for the state to get in the way of.
All right, stick around. We've got more Rising coming up next.